The U.S. Supreme Court convened today behind closed doors, discussing whether or not to review a lower court ruling striking down California's Proposition 8. Their highly anticipated decision could come Monday. Vic Amar, as you well know, the Supreme Court gets 7,000 to 8,000 requests for cases to be reviewed. How do they decide? They only pick about 80 or so a year. What's the criteria, and why would Prop 8 be a good pick for them to look at?
The most important criterion is how important the legal question presented is, and how national the question is, how many people it affects, and relatedly, how much lower courts are struggling over that and related questions. So in the Prop 8 case, it's true that Prop 8 is a California-specific measure, and it's also true that the Ninth Circuit ruling invalidating Prop 8 tried to make its reasoning California-specific. But of course, California is such an important state, and the same-sex marriage issue recurs in different forms in dozens of other states. So that's why it might have some appeal for the Supreme Court. And
as you said, the Ninth Circuit narrowed it down, but when the court gets it, if they were to take it up, could they broaden it back up and make it a national ruling?
Indeed, they could. In fact, if, as I would expect, they might have some problems with the Ninth Circuit's California-specific reasoning, then they might feel they have to take on the more fundamental question of whether any state, under any circumstances, can deny the right of same-sex couples to marry consistent with the 14th Amendment, which is the big question that covers the whole country.
Now, DOMA also covers the whole country. It's a federal law, and they've got several cases they're looking at, including one here in California. So, how do those two things interact with each other?
Yeah, so they have almost a dozen cases involving same-sex marriage before them right now.
And just also define DOMA, if you would.
DOMA is the so-called Defense of Marriage Act passed in 1996 that, among other things, says that for federal benefits and federal tax and other federal purposes, marriage shall be defined only between a man and a woman. And so a couple of different federal court of appeals in the Second Circuit and the First Circuit have struck down that aspect of DOMA, saying that the federal government has to treat same-sex married couples from those states that recognize same-sex marriage as married for federal purposes. So I think a lot of people properly speculate that the Supreme Court will have to take at least one of these DOMA cases, because when lower courts have struck down a federal statute, that's a big deal, and we got to get a resolution of that. Whether the Supreme Court says at the same time it's going to go ahead and take the Prop 8 case alongside, or whether it'll take a DOMA case and sit on the Prop 8 case for some period of months and then resolve the DOMA case and then see how it feels about Prop 8 after that is a more difficult question.
Yeah, historically, the court hasn't wanted to go too far ahead of what they see as a national consensus. So is it a fair bet that it's a safer, for them to take a DOMA case as opposed to the Prop 8 case?
Well, the legal question presented by the DOMA cases, namely whether the federal government has to follow what every state does when defining marriage, is in some sense narrower than the big question of whether states have to recognize same-sex marriage in the first place. But when you really look carefully at the arguments the federal government is making about why it declines to recognize same-sex marriage in states like Massachusetts that have it, at the end of the day, the DOMA case, when it gets resolved, is probably going to have a fair amount to say about the broader issue. So they're strictly speaking different legal questions, and you may want to proceed incrementally. But all these issues are really tightly related, and so even if the Supreme Court doesn't take the Prop 8 case straight away, what it says in the DOMA case may have implications for Prop 8.
So in balance, which case would, if it took it on, would have the bigger impact? I mean, to perhaps simplify what you just said.
Well, the DOMA cases affect people in all the states that have recognized same-sex marriage, Massachusetts, New York, etc. The Prop 8 case affects people only in California. So if you add up, the number of people in those other 8 or 9 states, I'm not sure if that's more than California, probably because New York is one of them. But in terms of if they were to take the Prop 8 case, and as Scott mentioned earlier, if they were to rule on the big question of whether there's a right to same-sex marriage, and they struck Prop 8 down on the same broad grounds, not that the Ninth Circuit did, but that District Judge Vaughn Walker did here in San Francisco, that would, of course, be the biggest ruling of all. That would have the biggest implication of all.
Because you would then have same-sex marriage in Mississippi and Alabama. Everybody always goes to Mississippi because that seems like the least likely place to have it, but it would be a national rule.
It would be a national right, although as Lauren pointed out that, the court may not be ready to take that step against a backdrop where we have 9 or 10 states that have recognized same-sex marriage, but they still comprise a pretty small geographic and even numerical minority. And you may not be able to count California as a true same-sex marriage state yet, because same-sex marriage has come about in California not by virtue of the voters or the legislature, but by virtue of federal court, the Ninth Circuit.
And Vic, you know, we've had just this month, there were 3 states additionally for the first time where voters approved same-sex marriage. So the political, the cultural, if not the legal landscape have changed a lot in the past couple of years. How does that affect the Supreme Court? How do they look at all that?
Well, you know, various of the justices have made clear that in deciding whether there is a national right that is protected in the name of the Constitution, the 14th Amendment, depends in part on kind of how deeply rooted the claim is in our nation's history and tradition. It used to be that the court focused on history and tradition kind of from long ago, but in one of the most relevant cases, a case from Texas, Justice Kennedy, and this was a case called Lawrence versus Texas, it involved a criminalization of same-sex activity. Justice Kennedy said the tradition and history that matters is the recent history and tradition. Now, 3 weeks is super recent, but if you have another 3 or 4 or 5 years, like the election in 2012, that could really change the landscape.
And of course, Kennedy, as always, the key vote, so they'll be looking very carefully.
It's hard to see that there'll be a right to same-sex marriage proclaimed nationally if he's not one of the justices saying that.
Yeah, all right, thanks, Vic. Well, Prop 8 has been mired in the courts for many, many years, but not all ballot measures are. In fact, just this month, voters approved overwhelmingly Prop 36 to reform the state's 3 strikes law, and already 2 3-strikers are out of prison. Michael Montgomery, how did that happen so fast?
Well, a couple of those cases, those 2 cases were actually in the works prior to the vote on Proposition 36. And in fact, in both those cases, the local district attorneys actually supported the petitions for a sentence reduction. And once the judge approved that, the sentence reduction was beneath the amount of time they've served. So both those men are out of prison. And the criteria that was established in their cases is pretty much in line with Proposition 36, which is that their 3rd strike was nonviolent, non-serious, and the DA accepted the notion that they didn't pose a threat to public safety.
Now, I know you recently worked on a documentary looking at 3 strikes, and you met some of the 3 strikers. I want to play just an excerpt from that documentary. We'll meet some of those men briefly, and then we'll come back and talk.
In the decades since America embraced tough-on-crime policies, its prison population has nearly doubled. Today, the U.S. has over 140,000 people serving life sentences. One of them is Forrest Lee Jones, a 3rd striker doing 25 years to life.
My 3rd strike is what they call a 1st-degree burglary of an unoccupied dwelling. That's entering unoccupied dwelling place with intent to commit larceny. I went inside of an apartment and stole a VCR.
At San Quentin Prison near San Francisco, Jones leads a prisoner support group called Hope for Strikers. Most of the men here say their 3rd strikes weren't violent.
My name is Eddie Griffin, and I got 27 years to life for possession of cocaine.
My 3rd strike is burglary of an unoccupied dwelling. It was my first relapse after being clean and sober for almost 10 years.
So, Michael, are those 3 men typical of the 3 strikers who were there? And what's the process for deciding who gets out under Prop 36?
Well, there's about 9,000 people behind bars on serving life terms under the 3 strikes law, the original 3 strikes law. Of those, the Department of Corrections estimates just under 3,000 might be eligible for resentencing under this new law. And you know, there's questions about whether all those people will get resentenced and whether they'll actually get released. The process is that an inmate has to petition the court, the county where he was sentenced, or she, and if it's determined that he is eligible, that he meets the criteria, then he will be resentenced, and that will entail a doubling of what would have been the original sentence without the 3 strikes enhancement. However, if the local district attorney wants to challenge that, he or she can on the grounds that the inmate might pose a risk to public safety, an unreasonable risk, based on prior offenses, based on time behind bars, perhaps incidents in prison.
Are there any timelines prescribed for when the resentencing has to take place, either if or the local DA objects or doesn't?
No, and I think that's one of the things that's going to have to be hashed out in terms of how this process works. You know, courts are overburdened as it is. We don't know exactly how long some of these will take. The inmates have to file their petitions within 2 years. That's
2 years of the enactment of Prop 36.
Exactly.
And are there kind of procedures to decide? I mean, for example, the DA objects. Then who bears the burden of proving that this guy should or woman should not be released? And by what standard are we deciding that question?
And is it enough if the DA says no? Is that the end of it? Or?
No. There will be an evidentiary hearing in that case if it's challenged. Now, this is assuming that the inmate is eligible, is determined to be eligible in the first place. Then there will be an evidentiary hearing. But the question of burden of proof is ostensibly on the prosecution. But who's going to determine, the criteria for the burden of proof?
And what kinds of evidence might be admissible to prove dangerousness?
Exactly. And I've talked to a number of prosecutors. Their biggest concern is that an inmate whose third strike perhaps was not serious and not violent may have had, a string of prior offenses, armed robbery, etc., that are violent, and yet the person could still be eligible. So some DAs are worried about people like that who do have violence in their past, but who are still eligible.
I mean, we've heard a lot about California's overcrowding problem in the prisons, people sleeping in gymnasiums. I mean, it sounds like even if everybody got out under this, it really wouldn't help that problem.
Well, it'll help a little bit. I mean, the Department of Corrections is down to about 6,000 or 7,000, or will be above the population cap ordered by the courts. So 2,000 out, that's going to help them get there. It won't get them the whole way.
All right, Michael, thanks very much. Very different topic now. Interior Secretary Ken Salazar announced Thursday that the historic Drakes Bay Oyster Company in Point Reyes National Seashore will lose its lease. The decision comes after a long environmental battle over whether the area should be restored to wilderness. And Lauren Summer, there was a very high-profile visit recently from Salazar to the Bay Area. How did it work its way up to the top of that food chain, if you will?
Seems a little strange, right? It's just one oyster farm. But what happened was the oyster farm is in Point Reyes National Seashore, and it had been operating there with special permission. So a 40-year lease that actually expired today. And what happened was the owner, Kevin Lunny, bought it in about 2004, and what he was hoping was to kind of convince the National Park Service to extend his lease. It became a huge battle, really about the identity of this place. So you had supporters of the oyster farm, like Senator Dianne Feinstein, saying this is part of the Point Reyes landscape. There's already ranches and dairies. And then the opponents, they argued that there was extreme environmental damage and that this area was slated to be protected already.
Well, what about Feinstein's point? I mean, if you think about an oyster farm, I mean, how much environmental damage can an oyster farm do? And what did the science say about the damage that they were doing?
And that's what's interesting here. The science was the most political part of this. So the National Park Service did an impact study. They said, well, we think that they do damage to the local habitat and they're disturbing harbor seals in the area. And then that became very political. You had people saying that they didn't do a fair job of that. And it was actually reviewed by a national panel of scientists who said they had slightly manipulated the data. So you can see how it kind of became a football in the whole debate.
Okay.
Well, no, I mean, obvious question, what's this going to mean for people who like to go up there and buy oysters? I mean, they're closing soon, and what does it mean for the supply of oysters in Northern California?
Yeah, they have 90 days to get out. It's not much time. There still are oyster farms up in Point Reyes, but this one just happened to be in an area that was designated as potential wilderness, and that was kind of the real problem here. It had been slated for potential wilderness in 1976. It's the highest level of protection that the federal government can give to a place.
And I think they produce like 40% of the oysters in California come from there. What is it about that particular location that makes them so productive? And can't Hog Island, which is up the road, can't they make up the difference? Yeah,
that's their number, 40%. But it is a big part of the Bay Area's landscape, and foodies in the Bay Area, they love the local oysters. So you could see there was a lot of opposition to this. It really has to do with individual leases. So each oyster farm has a particular spot that they lease from the state or the federal government. And this one just happened to be an area that was contested, and they knew that kind of going in.
Does this decision have any implications for other businesses, ranches, and other uses of the Point Reyes federal lands? Because I could imagine someone claiming those have environmental impact as well.
Right, and so there are a number of dairies and ranches in the area. What Salazar did when he made this decision this week is said, well, we're going to say that now the National Park Service, who gives the leases to these ranches and dairies, we're going to give them an option for a 20-year lease now instead of a 10-year lease. A lot of people think it was a signal to the ranches that we may have done this, but we're giving you a little signal that it's going to be okay.
Well, what's this? The phrase sustainable agriculture came in, and I think Salazar said that implied that this wasn't sustainable, that the oyster farm was not sustainable. What does that mean, and why was it not sustainable?
Well, what's interesting is that there was a lot of debate over the environmental impact, but what he actually ruled on was just the wilderness question. So it was designated as potential wilderness, which means when there's no commercial operation, it becomes the most protected area it can be. And so what he basically ruled on was that he wanted to see this place protected, and he kind of left the environmental damage question alone.
So that means that even if Lunny had been able to demonstrate very little or no environmental impact, he still would have lost, because this is basically a philosophical question of how wild wilderness should be?
Yeah, I mean, I think he was gambling on that. I think he was trying to demonstrate, you know, this is sustainable, we're part of the landscape here, and he was really hoping that he could make a case. And as he said this week, he's devastated.
And that would have applied to a dairy farm, say, had it been located at that spot.
Yeah, but those ranches and dairy farms are not in potential wilderness areas, so they don't have quite the same problem.
So what's so special about this area, this Drakes Estero? They're going to now restore it. So what is it about that location that's really unique?
Yeah, I mean, for the people that really advocated to get this oyster farm out, I mean, it's a beautiful landscape. Nobody's debating that. I think it's just a question of what people want to see this place be, right? Is it a place where we see commercial operations, or is it a place where it's completely protected, right? We don't see development or anything like that.
And their lease is up today.
Today.
So what happens to them? Are they going to get moved? Are they just out of business? They've even have some, I think, some oysters still in the water, don't they?
Yeah, they've got 90 days to get all of their equipment out. And, you know, Kevin Lunny kind of said this week he's not quite sure. They're looking at their options. There's no formal appeal process, so it kind of remains to be seen.
Did the federal government make any effort to help the dislocated employees and the like? And I mean, they give 90 days, which
How
is...
many are there? About 30?
About 30 employees, yeah. And that was something both sides said, that, you know, no matter what happened, they did want to see some job training happening for those employees.
And just quickly, Kevin Lunny, character? I mean, he seems like he's been out in the news a lot. Is there something interesting about him? Just, you know, quickly, he's obviously very well connected politically.
And he has a ranch in the National Seashore as well, so he's still there. I think he was kind of hoping that the debate would be a public debate, that people would say, you know, we love our local oysters, and it became a huge political football.